Tractate Kesubos discusses the laws of the marriage contract, referred to as a kesuba, and also the general obligations of the marriage agreement. Chapter 1 will begin discussing some points on the general laws of marriage. The first Mishnah says, "It's instituted that a virgin marries on a Wednesday while a widow marries on a Thursday." This is because courts were in session on Mondays and Thursdays back in those days, and if somebody wanted to go to court after a marriage to dispute the claim of his wife's virginity, he'd be able to go the next morning. The Gemara says, she's married on a Wednesday, not a Sunday, which is discussed. It explains that we want to give 3 days for the husband to prepare for the marriage feast, Sunday, Monday, and Tuesday, and also the husband is only obligated to provide her with food by Wednesday. There's debate if, based on this, the wedding was delayed, if the husband is obligated to provide her food at this time. It's explained based on a different discussion that if the wedding was unavoidably delayed, the husband is not obligated to provide her food, while if it was voluntarily delayed by the husband, he would be obligated. Some also add that this notion of unavoidable delay would not affect a divorce document. It's debated what the source for this is, a number of options are suggested and all rejected, and it's explained that it's just a logical conclusion. Essentially, it could either be that this notion of the impermissibility of delaying bringing a divorce document could either be a situation of a modest woman, so the husband just decides to delay here voluntarily, and she'll assume it was involuntarily and then just wait, unable to remarry. Or alternatively, it could be an immodest bold woman where the husband is actually unavoidably delayed, but she assumes he's just stalling voluntarily, so she'll remarry impermissibly and father illegitimate children. So because of this, it's deemed that there's no notion of delaying a divorce document. The permissibility of the court to enforce such a document is that as they're allowed to betroth a woman, they can also retroactively remove a betrothal, whether it was done with money or through cohabitation, in which case they could just retroactively rule that it was an illicit cohabitation, thereby nullifying the entire marriage. Others say it's actually the exact inverse of all of this, that we do apply the principle of an unavoidable circumstance delaying a divorce document. Again, various sources are suggested and debated. Anyways, we said earlier that marriages tend to be on Wednesdays. This was instituted after the enactment that courts would convene on Mondays and Thursdays. Before that, people would just marry whenever. And they could also still do that now if the court also convenes whenever, obviously assuming you took care of the wedding preparations before Shabbos. This is discussed at some times. It became dangerous to marry on Wednesday as it was instituted at some point in this time historically that anybody married on a Wednesday had to go to the local governor and cohabit with them first, and many modest women would treat this as a life-threatening matter, among other issues. So anyways, people started marrying on Tuesday, which was fine, but to marry on Monday was only done due to an unavoidable circumstance, such as a general and an army coming to town during the week and a while after, and there's a worry they'll cause issues with the wedding if it's done any later than this date. Alternatively, the unavoidable circumstance is the sudden death of a relative while they're finishing the wedding preparations, so they can just marry earlier, have the wedding, and then do the burial without delaying it. This applies if it's the father of the groom that passed, or the mother of the bride, as if they delay the wedding then no one will re-prepare it. It further says that the wedding must have been prepared to the point where the food has all been prepared, as if it could just be resold and rebought later. They can just delay the wedding until afterwards. We bring sources. It clarifies some further laws in regards to a mourner getting married. We also say that in the event that a marriage occurs towards the end of the week, you shouldn't cohabit with your wife for the first time on a Friday night, as you could cause bleeding, creating a wound of a sort, and you can't create a wound on Shabbos. And it also shouldn't be done on the night after Shabbos, and there's debate why that's not allowed then exactly. There are a few suggestions. It said to be impermissible out of concern that he might slaughter a bird to prepare as a wedding meal after Shabbos ends, which would also be an issue for cohabiting on a Friday night. There's also debate generally as to when the act of cohabitation takes place by marriage. By a Wednesday, it's said that by marrying a widow, it's done on Friday, either as there's blessings there, or so that way we make the husband spend time with his wife for the next 3 days, Thursday, Friday, and Shabbos. There are some practical differences, either if the man doesn't work or a holiday fell on a Friday, where we know he'll be spending time with his wife either way. It cites some related verses on this as a side point. It says your fingers are shaped in a point based on a verse, so you can plug your ears if you hear someone saying something improper, like gossip, for instance, which is a very negative thing to listen to, which is also why you have earlobes. Anyways, it further debates if cohabiting for the first time with someone legally constitutes as the creation of a wound, which would make such an act for the first time impermissible on a Shabbos, depending on what type of blood you hold that that wound creates, and whether or not this is considered to be a destructive or a constructive act. There are several opinions who disagree on this matter. We cite a number of sources which seem to imply that it would be permissible to do such a thing. There are several different opinions listed ruling as to whether it is or is not permissible. The final ruling is that it is permissible to cohabit with a woman for the very first time on a Shabbos. It also speaks on some of the blessings said by a wedding. These are further discussed. There are 7 blessings called the Sheva Brachos said in the house of the groom, although in Judea they would sometimes say it in the house where they did a rusin, the final stages of marriage. It also lists the text of the blessings. It says they're said before 10 people, all 7 days of rejoicing, although others say only when new people come to the meal, and it further lists all the text of these blessings. These and further variations as to how the blessings were read are discussed further. There are some particular related incidents mentioned, and further phrasing on other blessings, like by a mourner and similar. By the Sheva Brachos of a wedding, there are also several cups of wine that are drunk before eating, during eating, after by the after blessing, and others, which were instituted, one of which is drunk in honor of the sage Rabban Gamliel, who set the practice, starting with himself when he passed, that he should be buried in very cheap garments to allow burial to be easier on poor people, as now everybody also used cheap clothing. Anyways, in regards to actual testimony that somebody would make that the wife he married was not actually a virgin, we believe him, and they can no longer be together. This is clarified to apply either if he's a Cohen, meaning she'd be forbidden to him even if she was violated anyways, or it was a case where a father accepted betrothal on his minor daughter under 3 years and a day old to eventually one day have this marriage go through when she becomes an adult, when she's actually legally allowed to marry, in which case the cohabitation must have occurred way later after this, as you're not allowed to cohabit with somebody that young. This case is further discussed. There's debate if this is a valid ruling based on other sources. Some also say in such a situation she doesn't get her marriage contract, although this is similarly debated if it requires actual evidence of an absence of blood or not. It also disputes if the notion of a kesuba, the marriage contract, is of biblical origin or not. It also cites some specific cases of people who came to sages claiming their wives were not actually virgins when they married. One was actually admonished for this, as the only way he could have been an expert in such things was if he was frequenting harlots, and the other was said that perhaps his act of cohabitation was done at a slight angle, so it didn't appear to him like she was a virgin. There was another incident where a couple came before a sage, one saying she hadn't bled, the other saying she was a virgin, so he soaked the sheets in water and found some blood. There are several other similar incidents mentioned. New Mishnah. The Kesubah, the document given at the start of a marriage, contains the stipulation for an agreed-upon sum of money to be given to the wife upon the termination of the marriage, either through divorce or widowship. For a virgin, it was typically in those days done at a minimum of 200 zuz, which was an old form of coin, and for a widow was lower than that, 100. A virgin who was widowed, divorced, or had done chalitza while in erusin, the final stages of marriage, her kesuba is still the full 200 zuz, although the husband can make a claim against her if he finds she's not a virgin. The Gemara cites a few verses which source some of this terminology. It also speaks a bit on the health benefits of dates, and some other points on etymology. New Mishnah. A convert, a captive, and slave girl, if they were a child under 3 years and a day when they were ransomed, converted, or emancipated, eventually, when they get older and marry, their kesuba dowry is still the full 200 zuz for that of a virgin, although a claim could be made against them. The Gemara debates if a minor is allowed to be converted by a court. If a minor had been converted, there's discussion on if she needs to reconvert when she becomes an adult. New Mishnah. In the event, God forbid, that somebody had cohabited with a minor girl, or in the case that a minor boy had cohabited with an adult female, or if a woman became no longer physically a virgin by an injury from a piece of wood or something, their kesuba, when they eventually do marry, is still the full 200 zuz as if they were still a virgin, meaning they are not held responsible for any of these events occurring to them. Some say by the injury, however, it is actually reduced to 100. A virgin widow, divorcee, or somebody who had done chalitza from nisuin, the first stage of marriage, their kesuba dowry is 100 zuz, and they can't have a claim made against their virginity. A convert, captive, or slave woman who were ransomed, converted, or emancipated when they were older than a child, meaning over 3 years and a day, when they eventually get married, their kesuba dowry is 100 zuz, and they can't have a claim made against their virginity. The Gemara says, as a minor boy cannot legally cohabit with anybody in a circumstance where he had, it's considered the same as if the woman was injured by a piece of wood, and she has her dowry paid in full, according to some. Similarly, if, God forbid, a man had cohabited with a minor girl, that does no damage to her dowry when she eventually grows up, and she'll still be given the full 200 zuz when she one day gets married, as she's not in any way held responsible for that thing which occurred to her earlier on in her life. These points are for the discussion. There's debate based on this if the standard amount given to a woman who was said to be a virgin and was then found to not be one is only 100 zuz. Some say it's actually nothing. This was just unique, as the woman in question was already married before, so the husband should have at least suspected she was no longer a virgin. There's variation on this discussion, which is qualified. New Mishnah: if somebody eats in his father-in-law's house in Judea without witnesses that he didn't seclude himself with his betrothed, he cannot make a claim against her virginity after they marry, as they would typically have secluded themselves. The Gemara says that even within Judea, there was some variation between customs in different places, and this is discussed. New Mishnah: a widow, whether she's a Kohen or not, has a Kesuba dowry of 100 zuz. The Kohanim would typically give 400 zuz as a Kesuba if their wife was a virgin, which was permitted. The Gemara says for Kohanim, by widows, it was initially 100 zuz, but then people started treating the marriages lightly, so they raised it to 200, but then people stopped marrying widows, so they brought it back down to 100. It also says an eminent family, not just Kohanim, could set the contract to 400 zuz. New Mishnah: if somebody marries a woman and finds she's not a virgin, but she says, I was actually violated by somebody after you betrothed me, so it shouldn't affect the contract, while he claims it occurred before the betrothal, there's a debate as to who we believe. The Gemara says generally if somebody says to a person that you owe me money, and the person says, I don't know, there's a debate if he needs to pay it. Some say he does, that's a definite argument against an uncertain one. Others say he doesn't need to pay it, as the money should stay with who currently has it. Anyways, it suggests that possibly that's the same logic as the arguments by this case. Some say no, as there's a principle known as migoi by the case of the betrothal, which essentially states that as she had a much better claim, which wouldn't have been able to be disputed at all, like that she lost her virginity from an injury, for instance. So there's an additional reason to believe the woman by that case, as she chose to not make a much better and easier believed argument, while such a thing doesn't apply by the situation where somebody claims that the other person owes them money, as no such principle applies there in that situation. We say we follow the opinion that a definite statement doesn't override an unsure one. However, by our Mishnah, due to the difference between the cases and the additional reason to believe the woman that was described, we do believe her. New Mishnah: if a woman says she was no longer a virgin from an injury, and the husband says it was from a prior person, actually, it's debated who we believe. Some say the woman, some say only if she brings proof. The Gemara debates if the situation is where it's between paying 200 zuz and 100, or 100 and nothing, based on what you hold the payments are. It also lists the case in addition to the prior, to teach the extent of the differing opinions. The first says she's not believed in spite of the migoi claim. The second, which says she's believed in spite of the lack of a migoi claim. New Mishnah: if the court saw a woman speaking to somebody and they ask what his status is to see if it'd affect her marriageability, and she says he's a Kohen, meaning not an illegitimate person, there's a debate if she's believed or if she needs proof. Similarly, if a woman is pregnant and she says the father was a Kohen, and not somebody illegitimate, some say she's believed, some say she needs proof of this. The Gemara says that when it says that she was speaking to somebody, that either means that they were in seclusion, or it's just a euphemism for cohabitation. This is for the discussed. The logic of these cases is for the qualified. It also debates if such a woman's daughter is considered legitimate or not. It's debated as to who we hold like, and further discussed. It's additionally debated. New Mishnah: there was an incident recorded where a girl was violated by a man from a town. It was ruled that if majority of the members of the town were fit to have their children marry a Kohen, this girl's child should be allowed to marry a Kohen legally. The Gemara further discusses this. There are further points on different majorities that create a presumption that a child is eventually allowed to marry a Kohen, and there are some particular instances discussed and some additional qualification on these laws. And that's the end of Chapter 1. Chapter 2 of Tractate Kesubos discusses further laws of marriage and the marriage contract. The first Mishnah says if a woman was widowed or divorced, meaning she collects her marriage contract at that point, and she claims she was married as a virgin, meaning she should receive the full 200 zuz coins, while those paying claim she was married as a widow, meaning she'd only be paid 100 if we have witnesses that by her wedding she was sent out with a hinuma, which will be defined, or with her hair down, and some say if parched grain was given out, as was the custom if the woman was a virgin, meaning there are proofs that at the time of the wedding she was a virgin. She's now paid the full 200 zuz. Another point, if somebody goes to a man and says he bought a field from his father, he's believed, as this guy was unaware of the field in the first place, so the only proof it was ever owned by somebody else is from the person who owns it. However, if there are other witnesses that it was owned by the other person's father, he's not automatically believed if he says he bought it from him. The Gemara debates the logic of the first case. The implication seems to be, as the woman has witnesses, that if there were no witnesses, she wouldn't be believed. This would be different from a case from the prior chapter where the woman was believed, according to the opinion that it was a definite claim, which overrides an uncertain claim, as our case is a definite claim versus a definite claim, essentially, as most women marry when they're a virgin. Based on this, there's also a question as to what the other opinion, which references the concept of migoi, the notion that somebody would be more likely to be believed if they had the option of giving a more easily believable testimony and instead chose to bring the one they brought, is exactly referring to in the earlier chapter. There are several suggested cases brought. It also suggests that although majority of women marry as a virgin, this wouldn't help here, as typically it's also public knowledge, unlike by this case. It also says there's no concern of the woman reusing the Kesubos contract in different courts, as possibly we write a receipt, possibly because this is a situation where the contract isn't written. This is further discussed. It also mentions several different practices that were done by the weddings of virgins, such as passing a cup of teruma wine, a barrel of wine, and also singing and dancing was done. There's also debate between Beis Hillel and Beis Shammai if we praise a bride on her beauty at her wedding, even if she's not actually beautiful. It lists a few others of such blessings, and it talks about the importance of dancing before the bride and groom at their wedding. It also says we hold it's not allowed for people to gaze at the bride during the 7 days of celebration. It also says if there's an entourage carrying a corpse, they're diverted for a bride and a corpse, and a bride is diverted for a king. A king, Agrippas, once diverted himself for a bride, and it's debated if this was proper. It's said that it was at a crossroads, so it was fine. It mentions other obligations by a wedding or funeral. It says many shofars were blown to honor the dead. The amounts are debated. Also, the definition of a hinuma is either a myrtle canopy or a veil. It discusses other things done at weddings if the bride was a virgin. The next point was by the field case. It said a case where the man claimed he purchased the field from the other man's father and not from the man himself, unbeknownst to him, as that case doesn't really work for listed reasons. This is discussed. It also discusses the effectiveness of a legal protest not lodged in the occupant's presence, if this is effective, which is debated. It also proposes other cases it could have discussed, but rejects them based off of individual issues, and it's further qualified. New Mishnah, if witnesses certifying a document say this was our handwriting, but we were coerced to sign, or we were minors when we signed it, or we were otherwise unfit to testify, they're believed, as the only person suggesting that it was legitimate was also themselves. If, however, there were witnesses that it was signed by them or otherwise verified, they're not believed if they try to disqualify their own testimony. The Gemara suggests that if they say that they signed the document under threat of death, they'd still be believed even if their signatures had been verified by a third party. This is rejected as witnesses who testified cannot re-testify to retract their prior testimony. Rather, what it means to say is that if the witnesses testify that they falsified their testimony because of a threat to their finances, they're not believed, as there's a rule that a person cannot establish themselves in court as a criminal. There are related points. It quotes an opinion that says witnesses who authenticate their signatures on a document are not believed to invalidate it. This is because the document is valid even without their certification, as the individual conceded that he had drafted it. It also holds that if somebody has a debt document that he said was written on trust, he's not believed. There's debate as to what kind of document exactly he's referring to, and there are related cases discussed. Furthermore, if witnesses have signed a document and died, new witnesses can't appear to contradict the validity of the original testimony, as it's the two witnesses versus each other now. So the current status just remains as it is. We bring sources. In regards to certifying the validity of a document, some say you can only compare it to a document that was challenged and verified. Some say you can also compare it to two Kesubos marriage contracts or bills of sale of two fields, provided that the owners used the fields peacefully for 3 years after, and this is assuming the documents were procured by somebody other than the person whose document is actually being questioned. And there are further points on the laws of written testimony. It also discusses some laws of impurity, which we use to teach that a witness can testify on something he saw up to 60 years ago. Others say it should be more, as people will take care to remember something that they need to testify on. New Mishnah: if two witnesses verify their handwriting and their fellows, it's valid. If each person can only validate their own handwriting, some say they need to get another person to verify their handwriting, others say their testimony is sufficient. The Gemara debates exactly what this case is referring to. It also cites an opinion that if two people are witnesses and one of them dies, two new people must authenticate the signatures and one can't be the original witness. If there's one new witness, then the surviving witness should just write his signature on a shard so that way it can't be used afterwards for forgery by others, and it will then be used to verify his original signature. It's said that we rule that the two witnesses can just verify themselves. It lists a few unique related cases. Furthermore, some say a witness and the judge can combine to authenticate signatures, but this is rejected. There are other specific cases brought, and these are qualified further. New Mishnah: if a woman says, "I was married and got divorced," she's believed, as she's the only source of this information. If there are witnesses, however, that testify that she was married, she's not automatically believed that she was divorced. Similarly, if a woman says she was held captive but remains pure, she's believed because she's the only source of this information. If there are witnesses that say she was held captive, we don't automatically believe her if she says that she's pure. If these witnesses came after she married, she nevertheless doesn't need to leave her husband. The Gemara cites sources for these rulings, and it also cites some particular cases. There are further particular cases brought. Some say if two witnesses say a man died and two witnesses say he did not, the man's wife cannot remarry. If she did, she can stay married. If two witnesses say a woman was divorced and two say she was not, she cannot remarry, and if she did, now she would actually need to divorce. There are a few suggested differences between these cases. The first is that it was actually one witness testifying by both cases, where there's a special exception to believe that the husband died, or it's that there's a stricter opinion accepted by divorce, as she can contradict the husband's claim if he says he didn't divorce her, so long as there are no witnesses, or it's that the witnesses testify that the death or divorce happened today, which can't be verified by the dead husband, but it can just be verified by the divorce, as they could just have her show the divorce document that she should have received. And there are further particular cases discussed. The other points are further qualified, along with bringing some instances of a few actual cases. New Mishnah: if two women were held captive and they testify about themselves that they're pure, they're not believed. They are believed if they testify about each other. The Gemara discusses some related particular instances. If a woman testifies about herself, saying she was made captive and violated, she's believed. If she says she's pure, she's believed, so long as there aren't other witnesses to testify to her captivity. If a woman testifies that another captive was violated, she's not believed, unless witnesses testify to their captivity and there are no witnesses that say she wasn't violated. If a woman testifies that another captive is pure, she's believed, regardless as to what the other witnesses testify. New Mishnah: if two men testify about themselves that they are Kohanim, they are not believed. They are believed if they testify about each other. Some say we can't make somebody a Kohen based on one witness. Others say that's only if it's contested. Others say we can, even if it's based on one witness. The Gemara explains the necessity of these cases, and they're further discussed. It also debates the evidence level required to elevate somebody to be a Kohen. It's debated if you can use documents, or if it's just based on the fact that he, at some point, said the priestly blessing. It tries to bring many further proofs for the latter point, which are further discussed. There are additional suggestions brought, attempted proofs from having seen the individual reading from the Kohen portion of the Torah and similar. It also says that casual speech could work to establish somebody as being a Kohen. It gives an instance of a man who casually mentions that his father would give him teruma, a tithe, which can only be eaten if you're a Kohen, when he was younger, and he was therefore established to be a Kohen based on that. And there are further similar points brought, and it debates if having received Ma'aser Rishon tithes, if that's sufficient proof, and that's further discussed. New Mishnah: if a woman is imprisoned by people who worshipped idols, if it was for monetary matters, she can be with her husband after her release. If it was for capital punishment, she can't be with her husband if she gets freed. The Gemara clarifies, if the Jewish people are actually ruled over by these people, then she's not allowed to be with her husband in either case. And there are some other instances discussed, along with some additional points. New Mishnah: if a city fell to a siege, all wives of Kohanim within can no longer be with their husbands, unless they have witnesses that they weren't attacked. We'd even believe a slave or slave woman's testimony here. We don't, however, believe somebody's testimony on themselves. The Gemara says that, unlike by the woman, there's no concern that they used wine barrels for idolatrous libations, as there'd be no time. It also clarifies that this is a city besieged by a different kingdom, not by a city besieged by its own same kingdom. And there's no concern of somebody slipping past the army into the city, as it's sufficiently guarded in this case. Some say if there's even a single hiding spot in the whole city, all of the women within are presumed to not have been attacked and violated. There are related points discussed. It also argues that if a woman says, although there was a valid hiding spot, she didn't use it, but she still wasn't attacked, she's in that case believed. It further clarifies which testimony is accepted by such a situation. New Mishnah, there was a sage who survived the Roman siege of Jerusalem, and he swore that he had stayed with his wife the entire time, and she was not attacked. But he was told that a person still can't testify on his behalf. The Gemara discusses related points, and there are further related laws here discussed. New Mishnah, the following are believed in their testimony of something they saw back when they were a minor. Somebody who testifies on the handwriting of his father, teacher, or brother, the fact that a wedding occurred in a manner typically done for a virgin bride, that somebody did things that implied he was a Cohen, or that a location is a plowed over graveyard in regards to the laws of impurity. He is not trusted by monetary claims, like that somebody had a path through a region, or a designated eulogizing spot or similar. The Gemara says that all of this applies if there's also an adult testifying along with him. The remaining points are qualified, and it explains why these testimonies are believed, such as that generally most women marry as virgins anyways, whether a person was a slave or not, and the points on eating teruma to verify that he's a Cohen. The remaining points are also further discussed. And that's the end of Chapter 2. Chapter 3 of Tractate Kesubos continues discussing various laws of marriage. The first Mishnah says, if a Na'ara, a girl in a middle stage of adulthood, is illegitimate, or a Gibeonite or a Kuthian, and is violated, God forbid, she's paid a fine. If a convert, captive, or slave girl who were ransomed, converted, or emancipated as a child were violated, they're also paid a fine. If somebody violates his own relative, his sister, aunt, sister-in-law, father's brother's wife, or a nida, a menstruating woman, they're paid a fine. This is although the violator is also subject to the punishment of kares. The Gemara further clarifies these points. It also discusses the verses which source these laws, and it qualifies which opinions on these laws these statements seem to reject. There's also some additional points on the different forms of capital punishment that used to be administered when there was a Sanhedrin. There are related points discussed, and this is all qualified further. It also mentions other forms of reimbursement for such crimes. There's an apparent contradiction. Our Mishnah says a person who violates his sister is liable to pay a fine, while a later source says he's liable for lashes. The difference between these cases is disputed. The other one could be where he was warned beforehand, possibly, but this is discussed, and it cites some sources. It quotes additional verses as sources for several of these laws and similar, such as for financial reimbursement after injuring somebody, and these sources are further qualified. It also discusses the various punishments for the violation of various other prohibitions. It's on things like particular violations of the Shabbos and similar. Further, some would hold by that later source that the punishment for somebody violating their sister is both lashes and a fine. And this is further debated as to why some hold like this and others disagree. There's further discussion on this and some similar related points. It cites further rulings on these fines by additional particular unique cases, and these are all discussed further. New Mishnah, the Na'aras who aren't entitled to a fine are as follows: a convert, captive, or a slave girl who were ransomed, converted, or emancipated after they were a child. Some say a captive who was ransomed is presumed to not have been violated, even if they're older than a child. Also, there's no fine if the violator is liable for the death penalty, such as someone who's with their daughter or granddaughter or stepdaughter. The Gemara discusses related opinions. It further debates, based off sources, if captives are suspected of having been cohabited with. It also discusses the very source for the point that somebody who was liable for capital punishment does not have to pay fines. These verses are further discussed, and there's some additional qualification. New Mishnah, if a Na'ara was betrothed, divorced, and then violated by somebody, there's debate if she's entitled to a fine. The Gemara explains that this is based on the interpretation of various verses on this subject, and the differing opinions are discussed and additionally qualified. New Mishnah, a seducer pays for humiliation, deprecation, and a fine, while a violator also pays for the pain he caused. Further differences, a violator pays the fine immediately, while a seducer pays it when he sends her away. Also, a violator can be forced to marry the woman and take care of her financially for the rest of his life, even if she's extremely undesirable, unlike by a seducer. The exceptions to this marriage by a violator are if she's found to have committed adultery prior, or she's illegitimate, which is based on verses. The Gemara debates which pain exactly it is that the violator is being fined for. The other points on the differences between a violator and a seducer are further qualified. New Mishnah: if an orphan was betrothed and divorced, a person is liable for violating her and exempt for seducing her. The Gemara argues on the source for this ruling. New Mishnah: payment for humiliation is determined based on both parties involved. Depreciation is calculated by assessing how much the woman would have been sold as a slave in theory before and now, based on the difference between the two sums, similar to the whole concept as to when a person pledges their worth to be given to the temple, and the fine is a fixed amount. This notion of fixed fines applies by all monetary liability in Torah. The Gemara debates that the set 50 shekel fine does not include within it the fines for humiliation and depreciation. It also debates who receives these fines based on sources. It's debated if it goes to the woman or to her father. It says there's no biblical source for this, but logically it should go to the father, as he generally got to make decisions for his daughter. It describes how the depreciation value is calculated. New Mishnah: in some places it was done that a father would sell his daughter as a maidservant to serve for several years, and then would marry her master or his son. There's either permissibility for such a law or punishment for violation or seduction. A minor could be sold by her father as a maidservant, but wouldn't be subject to such a penalty. A na'ara would be subject to the penalty, but can't be sold. A bogeres, an adult woman, can't be sold or entitled to the penalty. The Gemara further qualifies points in these laws. If someone had admitted that they seduced somebody, they pay for humiliation and depreciation, but not for a fine. If somebody admitted that they stole, he pays the principal, but not extra. If somebody admits his ox killed somebody or an animal, he repays the amount, but not if he says it killed a Canaanite slave. Generally, if somebody would have had to pay more than what he damaged, he doesn't pay based off of his own admission. The Gemara says it doesn't mention a case of violation, as that's obvious compared to the seduction case, as there he discredits the woman. Others disagree with many of these points. It cites several sources which imply that half damages are considered compensation, not a penalty. These are further discussed. It's ruled that half damages are actually considered a penalty, and this has relevance by several particular cases. And that's the end of chapter 3. Chapter 4 of Tractate Kesubos continues discussing the laws of marriage, here particularly in regards to the fines of a violator or seducer. The first Mishnah says, a na'ara, a girl in the middle stage before adulthood that was seduced, the payments for her humiliation, depreciation, and fine all go to her father, as does the payment for pain by a violator. If she sued the man in court before her father died, the payment goes to her father. If the father died before all of this, the payments go to her brothers. If she sued after her father died, it goes to her. If she sued before she became an adult, the payments go to her father, and if he dies, her brothers. If she sued after she became an adult, it goes to her. Some say if she sued while her father was alive, but he died before she could collect the actual payment, the money goes to her. Generally, any of the girl's earnings or fines, if they're uncollected, if the father dies, they go to the brothers. The Gemara explains this is very repetitive of the last Mishnah, but it's to teach that the money goes to her father, and also to teach the dispute between opinions as to where the money goes if she sued the seducer while her father was still alive. It cites a later case that if an accused man denies having seduced or violated somebody and then later admits that it was him, there's a dispute if he pays the fine based on if you hold you can make yourself pay a fine based off of your own admission, although he definitely still would need to pay for the humiliation and depreciation. It said that if he denied having been sued and having to pay the fine, that is considered a denial of monetary obligation, and he'll be liable to bring an oath offering. The logic of this case is further debated. A related point, if a daughter is being supported by her brothers from the estate of their father, there's a question if her earnings go to the brothers in place of the father, or if that's not a valid comparison. And we try to compare it to a related case involving a widow, saying that it should go to the brothers, but this is debated. It's said, based off of a different case, that actually the earnings stay with her, not the brothers, and we bring opinions which corroborate this and sources. This is the final ruling. New Mishnah: if somebody gives his daughter to be married and the groom divorced her prior to the completion of the marriage, and then they restarted the marriage process again, and then he died before they could complete it, both marriage contracts go to the father. If the same case happens, but both times the marriages ended after the final stages of marriage, some say the marriage contracts go to her, some say only for the second marriage. The Gemara says an opinion that she's still allowed to remarry after this, but she wouldn't if she had been widowed 2 times in a row, according to the opinion that such a presumption of reoccurrence is established after 2 occurrences. The logic of the contracts going to the father is that they were written while she's still under her father's jurisdiction. There's debate as to when exactly the base marriage contract of 200 or 100 zuz becomes applicable. Some say it's in the initial stage of marriage, some say it's only after the completion of the entire marriage, and this is debated. The logics are further explained, and it's ruled that all of the contract amounts are collectible after the final stage of marriage. New Mishnah, in regards to a female convert who converted along with her daughter, and the daughter did adultery, the daughter is liable to capital punishment, which back then was strangulation. She's not subject that this occurs at her father's house, and if it turned out that her husband had defamed her, she's not entitled to a fine. If her conception was prior to conversion, but her birth was after, she's instead liable for stoning, and the other 2 points also don't apply. If she's conceived and born after conversion, she's like a Jewish woman in all other respects by these laws. If she has a father but doesn't have a house, or she has her father's house but no father, she's still liable for stoning. The point being that it should be by her father's house, as mentioned in a verse, is just an additional obligation. The Gemara brings sources for these points. It also says regarding the fine for defaming an orphan girl, the verse says you give it to her father. So if she has none, some say it's just not given, assuming the cohabitation happened while she had no father. This is further debated along with if it's required to pay the fine if somebody defamed a minor girl. This is further debated, and there's additional discussion on this point. It also debates based on other sources whether the term for lashes can be used in reference to a monetary loss, and it discusses the punishment for a defamer being lashes, which we bring sources for. It also debates if this still has applicability if the defamed in question and the woman did not ever actually cohabit, which is based on the interpretation of the verses. Uniquely, there's not typically difference drawn by these laws of cohabitation in regards to either the natural or atypical forms of cohabitation. The ruling is usually the same, except by a defamer, where this only applies if the husband is accusing his wife of having done adultery in a natural manner, and also they had cohabited themselves in a natural manner. New Mishnah, a father legally has the right to betroth his daughter, receive the money, accept the betrothal document, or give to be betrothed through cohabitation. He's entitled to her fines and earnings, he can annul her vows, and he can accept her bill of divorce, although he doesn't get to eat the produce of her field. Once his daughter is married, the husband overrides all of the father's rights, although he also gets to eat her produce, although the husband is now also obligated to give his wife sustenance, ransom her if necessary, and pay for her burial. Others say even the poorest man in Israel must hire at least 2 flutes to mourn for his wife at her funeral. The Gemara cites sources for all of these rulings, going through all of the applicable verses. These are further discussed, going through all the sources for these points, and it additionally discusses the husband's obligations to support his wife. It also discusses the points on the obligation to have flutes by your wife's wedding. Some say that what it's referring to is specifically the opinion which holds that it's an obligation where it's the custom of the man's family to do so. It said we follow this opinion. It's also said if somebody went insane, the court goes through his property and supports his wife and children, and some say also gives adornments for his wife, and some say charity. The logic is debated. If a man is overseas and his wife dies, the court goes through their property to bury the wife according to her status, or at the very least according to his status. This teaches that a woman rises to her husband's status, but does not descend to his status even after her death. Another ruling, if somebody says that if he dies, he shouldn't be buried from his own property, we don't listen to him, as people shouldn't be able to make their families richer off of the public wealth. New Mishnah, a girl is under the domain of her father until she's in her husband's domain in a completed marriage. If the husband gives the daughter to the husband's messengers who will deliver her to him, she's considered in the husband's domain at that point. If the father or his agents went with them, she's still considered to be in her father's domain. She's in the husband's domain once the father's messengers have given her to the husband's messengers. The Gemara says this disputes the opinion that a girl can't eat teruma during her betrothal to a Kohen, and it further debates the legitimacy of using messengers to deliver a daughter to a husband. This is further discussed. There are further points that says that once a woman enters her husband's household, if somebody does adultery with her, they're liable to the capital punishment of strangulation. New Mishnah, a father is not obligated to provide his daughter's sustenance. Based on the wording of the marriage contract, it's implied that the same way sons inherit after their father's death, a daughter is sustained after her father's death. The Gemara clarifies based off this wording that a father is still obligated to provide sustenance for his sons, and he does have a mitzvah to do so also for his daughter, and it debates whose opinion this holds like. This is further discussed, and some are of the opinion that a father must sustain his minor sons and daughters, although we bring a few sources that the court can't force a person to do this unless he's wealthy. It also debates if somebody wrote off all of his possessions to his children, he and his wife are still sustained from them, and it said we don't rule like this. Generally, it's proper to give a tenth of all of your income to charity. If you want to give more, it said you shouldn't give more than a fifth, and it brings sources. There are also other points. It also says how and when to discipline a child who won't learn, and some medicinal treatments for a sick child. There are further related points and expansion on a few verses on the importance of charity, and likewise, it further qualifies which property should be given to support children as to whether or not you can use movable property, and this is further debated. New Mishnah, if a groom did not write a marriage contract, if he married a virgin, she gets 200 zuz. If she's a widow, she gets 100 as stipulated by the court. There are particularities by promising land. If he didn't stipulate that he'd ransom her, if necessary, in the marriage contract or similar, he's still obligated to do so as it's stipulated by the court. If such a thing does occur, he's not allowed to divorce her to just get out of it. If his wife gets sick, he's obligated to heal her, but here he's allowed to divorce her to exempt himself. The Gemara debates the author of this Mishnah. This is further discussed, along with if a Cohen's wife was violated, there's debate if she's allowed to remain with her husband after, out of concern that to some degree she'll have reconciled to the attack and the full act won't be legally considered entirely unconsensual. There's debate if this is held, others disagree with this point, and there are related points discussed. It also says that if a woman is held captive by a king, if it's of a major monarchy, the act of cohabitation is deemed non-consensual, and she'd be allowed to be with her husband after. If it was with a minor, irrelevant king, there might be a concern of her trying to marry the king, so she wouldn't be allowed to be with her husband after, and there's a similar point by bandits. This is all further discussed, and there's additional qualification. New Mishnah, if the marriage contract didn't say that the marriage contract would be inherited by their sons, that's still done anyways as a court stipulation. If it didn't say that their daughters will be supported by him until marriage, that's also still done, again, as a court stipulation. If it didn't say that after his death, his estate and house would still support her, that's still done as a court stipulation. The last point was done in Jerusalem and Galilee. In Judea, the heirs could just give the widow her contract payment and be no longer obligated to support her. The Gemara says that it established that part of the marriage contract goes to their children, so that way they'll give large dowries for their daughters, which will help marry them off. A dowry would be a tenth of a person's possessions. And this for the particular discussion on this. There's further qualification and points on what exactly a woman gives up if she waives her right to a marriage contract. Some saying she no longer needs to be given sustenance. There are particular instances of similar things given. There are related points on supporting a daughter, and there are a few other unresolved questions on these laws. A widow is supported by her husband's estate. However, it says not if she remarried, or even if she turned down a marriage offer from somebody if she felt that he was unworthy of her, or if she cohabits illicitly, and some say even if she dresses in a manner to try and attract other men, although it said we disagree with all of this, and it's held that her support ends when she demands the payment of her marriage contract. The remaining points are further qualified, and that's the end of chapter 4. Chapter 5 of Tractate Kesubos further discusses laws of marriage and the marriage contract. The Mishnah says, although the general principle is that a virgin receives a marriage contract of 200 zuz while a widow gets 100, you can add to this if you want. This amount is collected by her upon her becoming a widow or a divorcee, no matter what stage of marriage she's in. Some say she only gets any extra more than the default minimum 200 or 100 if they separated after she was fully married. If they agree, they can write the contract as the legal minimums, 200 or 100, and then afterwards have her give him back some of the money. Some say if the Kesubah amounts are beneath the minimums, cohabitation between them is considered non-marital and impermissible. The Gemara says it had to state that you're allowed to increase your Kesubah contract more than the minimum to say that there's not a principle of a set amount here to reduce the embarrassment of poor people. Further, a stipulation to add to the Kesubah is considered like the Kesubah contract itself, which has relevancy for several things, be it the woman selling her Kesubah, waiving it, impairing it, demanding it, and others. Further, it said that the Kesubah given to male children is not collected from encumbered properties. It's also ruled that non-intact movable property and designated land with one border can be collected from the Kesubah without an oath. It's also held that if somebody wrote a document of transfer, gave it to witnesses without legally acquiring it prior, they don't need to consult the donor prior to giving it. It's debated if we hold that it's only after the final stage of marriage that the woman collects any additions to the marriage contract, and this is further debated. It said that we do hold like that. There are further unresolved questions on this. In regards to the method of reducing the kesuba past its minimum by stipulating the full amount and then separately writing that she's giving money back to him, it's said that this only works if it's actually written. This is because it's a rabbinic decree regarding a certain matter which are treated stricter, so they'll be actually followed. Some hold that the kesuba, however, is actually of biblical origin, and this is further discussed. It's a lengthy debate as to the legitimacy of orally reducing a kesuba during select periods, be it at the beginning of the chuppah wedding ceremony, after that, but before cohabitation, and if it can be done after cohabitation. There are a few opinions within that as to when it would and wouldn't be permissible. New Mishnah. After the betrothal, if either party says they want to go to the actual marriage, the other can request time to prepare. A virgin or the groom are given 12 months to prepare. A widow is given 30 days. If the set time passes without them being married, the woman can eat of the husband's food or terumah if he's a Kohen. Some say all of his terumah should be given to her, some say half her food should be terumah. A woman who does yibum, the levirate marriage, until the actual marriage, she can't eat terumah. There are some particularities on this mentioned. It was later ruled that a woman can only start eating terumah once she enters the chuppah. The Gemara cites sources for these rulings from verses. It's forbidden and not allowed to set a wedding date for a minor that has her be married off while she's still a minor, particularly as it's rabbinically forbidden to have a minor daughter be betrothed anyways in the first place. However, it would be permissible to set a wedding date for such a daughter to be married once she becomes an adult, and there are related points on this discussed. It also discusses opinions as to how much terumah exactly must be given to a wife. There are sources for the other points also mentioned. New Mishnah. If somebody consecrated his wife's earnings, she can still support herself from them. If he consecrated the excess, it's a debate if it's still considered consecrated. The Gemara says some hold that a woman can tell her husband that he is obligated to support her, and she's not going to give her his income. The legitimacy of such a statement is debated. In regards to consecration of the wife's excess earnings, according to those that say it is consecrated, it's debated if it takes effect when the wife dies, or if it takes effect immediately. The logic is debated. This for the discussion, it said we hold that if somebody tries to consecrate his wife's future earnings, it doesn't take effect, and the particularities of this are debated. This is discussed further. New Mishnah. The obligations of a woman to her husband are to grind grain for flour, to bake bread, launder clothes, cook, nurse her children, make his bed, and work with wool. If she brought one maidservant into the marriage, she doesn't need to grind, bake, or launder. If she brought two maidservants, she doesn't need to cook or nurse. If she brought three, she doesn't need to make his bed or to work with wool. If she brought four, she can just do nothing if she wants. Some say no matter how many maidservants she brings, she should still work with wool, as idleness brings to unchastity. Others say that if a husband takes a vow prohibiting his wife from working, they must divorce, as idleness brings to insanity. The Gemara says as grinding grain is typically done with a water mill, either she's just tending to the grinding or it refers to a hand mill. There's disagreement on the other points. It's said from a different source that if a couple gets divorced but the child refuses to nurse from anybody but with the mother, the ex-wife must still nurse the child and is paid. There's debate as to how old such a child is. It's held to be 50 days. There's further discussion on this and on how and when a child nurses. There's also related rulings on these laws in regards to nursing discussed. It also mentions many actions by a woman which could lead to unhealthy or unique children depending on what they do or eat or similar. It further discusses the wife's obligations to nurse and it brings sources. It goes through the points on maidservants and also says that if she has four, meaning she can do nothing in theory, some say she should still prepare her husband's wine, make his bed, and wash him. These are the only actions a nida, a menstruating woman, cannot do for her husband, although she can make his bed when he's not there, and you can mix the wine if it's done in some specific manners, like not placing it directly before him and otherwise, and there are related points discussed. There's for the discussion, and we said that there was an argument if idleness brings to infidelity or to insanity, and there's a practical difference if the woman is occupied with playing with puppies or with chess. New Mishnah. If a man takes a vow that his wife can't cohabit with him, Beis Shammai says if it was for 2 weeks, it's fine. Beis Hillel says if it's for 1 week, it's fine. Longer than that, they must divorce. Students can leave their wives to study Torah without permission for 30 days. Laborers can leave for a week. The conjugal rights to a woman are as follows. Tayelin, which will be defined, are obligated every day. Laborers are obligated twice a week. Donkey drivers once a week. Camel drivers once every 30 days, and sailors once every 6 months, according to Rabbi Eliezer. The Gemara gives sources for these points. There are related points on this discussed. It also argues what a tayelin is. Some say it's a person who's totally self-sustaining and is not required to pay taxes. Some say it's a very healthy person, and it gives instances of individuals of great health. Laborers, conjugal rights, who are twice a week, if they work in their town, and it's once a week if they work in a different town. There are related points. It says that a husband shouldn't change his job that'll keep him away from his wife for longer. It also says that this is the opinion we hold like in regards to Rabbi Eliezer's list of mandated conjugal obligations. It also mentions an incident of a sage who was so engrossed in learning he forgot to go home to be with his wife, and his wife was so sad she cried and the floor that the sage was sitting on collapsed and he died. It says Torah scholars should be with their wives on Shabbos Eves, which is based on a verse. There are a few related instances discussed. There's a very famous story on the life of Rabbi Akiva. He started as an illiterate shepherd of a man named Ben Kalba Savua, whose daughter, Rachel, saw that Akiva was a good man and offered to marry him on the condition that he one day became a Torah sage. He agreed, but Rachel's father was very upset with all this, and he disowned her and took a vow against giving them his possessions. Akiva spent 12 years studying Torah and returned as one of the greatest sages of his time, with 12,000 students accompanying him. When he reached his house, he overheard a man criticizing Rachel for having his wife leave him for so long, and he heard her say, if he was here right now, I'd have him learn for another 12 years. So Rabbi Akiva took this and went immediately back and learned for another 12 years, and then returned with 24,000 students. So Rachel's neighbors tried to have her borrow expensive clothes to dress and greet him, but she wore what she had, and she approached him to greet him, and Rabbi Akiva's students started pushing her away, not knowing who she was, and Rabbi Akiva stopped them, saying both his and all of your portions of Torah belong to her. Anyways, Rachel's father, Ben Kalba Savua, heard that a great sage had come to town, not knowing that it was his son-in-law, so he wanted to annul his vow to support his daughter. He spoke to the sage, again not knowing it was Rabbi Akiva himself, and Rabbi Akiva asked him if he would have made his vow if he knew his son-in-law would have become a great sage, and Ben Kalba Savua said he wouldn't have if he knew his son-in-law would have learnt even a single chapter or law. So Rabbi Akiva revealed who he was, and Ben Kalba Savua gave him half his possessions. Rabbi Akiva and Rachel's daughter ended up doing a very similar thing to her husband, Ben Azai, sending him away for a long while to learn Torah. And there are a few other related incidents. New Mishnah: if a woman refuses to fulfill her marital obligations, you deduct 7 dinars a week from her marriage contract. Others say 7 trapaks, which was a different type of coin. Some say he stops when the Kesubo has nothing left. Others say you just keep going and deduct the amount from any inheritance she gets. If a man refuses to fulfill his marital obligations, he adds 3 dinars a week to the Kesubo, and others say 3 trapaks. The Gemara argues that the situation is that the woman is refusing to cohabit with her husband or to do work. This is further debated. The method of this instance is described, and there's further discussion on these laws, and it debates exactly what the trapeak currency was. Some say it was worth half a zuz, and it brings sources. It also says that a woman is charged more for refusing her marital obligations, as men typically are much more desiring of women in a more noticeable manner. New Mishnah: if somebody provides to his wife through a third party, he cannot give her less than 2 kav, a measurement of wheat, or 4 kav of barley per week. There's debate if she's given a barley stipend. He also gives half a kav of beans and oil, a kav of dried figs, an amount of pressed figs, and if he has none, he gives from a different fruit. He must also give her a bed, a soft and hard mat, a hair kerchief, a belt, and shoes from holiday to holiday. Also clothes worth 50 zuz from year to year, being new clothes in the winter, and she wears them in the summer, and she gets to keep each year's old clothes. He also gives a silver ma'ah a week from her other needs, and she eats with him on Friday nights. If he doesn't give the silver ma'ah, she gets to keep her own earnings. The woman's obligations are to spin the weight of 5 sala'im of warp thread in Judea, or the weight of 10 sala'im of weft thread in Judea, which are the equivalent of 20 sala'im in Galilee. If she's nursing, her earning amounts are reduced in exchange for food. These amounts have all been minimums for the poor. If you're any wealthier than this, it goes according to what you make. The Gemara debates the author of this Mishnah based on differing opinions on these laws. It's further discussed in regard to the barley. Those that paid double the barley amount, that was because theirs was of poor quality. It also says that there's no wine stipend, and it cites verses, although some say we do give it if she's accustomed to drinking wine. Some say if a woman is accustomed to drink 2 cups of wine when her husband's there, she's given 1 cup when her husband's not there, and if a woman is accustomed to drink 1 cup by her husband, she's not given any cups at all when he's not there. This for the discussion. Some say the other opinions say if a woman is accustomed to drinking, we give her wine for cooking, and there are related points on it not being good to drink in general. The mats the husband must give her are for her bed to make it comfortable. The constant need for shoes was because This was authored in a mountainous region, and also we want the woman to be happy by the holidays. It further discusses the different worth of the clothes. When it says she eats with him on Friday nights, some say this means literally they eat together, some say this is a reference to relations. This is debated based on sources, and it also says that by a nursing woman that you add wine, which helps nursing. And that's the end of chapter 5. Chapter 6 of Tractate Kesubos goes through additional laws of marital obligations and the Kesuba, the marriage contract. The first Mishnah says, a wife's fines and earnings go to her husband. If she inherits property, the husband can take from it while she's alive. If she's being financially reimbursed for being hurt, for humiliation and devaluation, it goes to the woman. Others say if it's a concealed injury, a third goes to the husband, and if it's revealed, he gets 2/3. His share is given immediately, and her share is used to purchase land, which he can benefit from. The Gemara says most of this is obvious, as we've said most of these in regards to her father's ownership also, and that a husband's ownership then overrides her father. So, rather, all of this was to bring the dispute by the injury reimbursement. There are further points, and it says a wife is unique in regards to being repaid for humiliation, as a man suffers disgrace when his wife is assaulted, as your wife is legally considered part of your own body. New Mishnah. If somebody pledges an amount of money to his son-in-law as a dowry, and the son-in-law dies, it's said he can choose to not give the dowry to the Yibum levirate marriage brother. If a woman brings money or goods into a marriage, the husband must reimburse them upon a divorce. He pays a 50% increase by pledged cash, and by appraised goods he pays a fifth less than their value, unless they were appraised and worth a set amount. If the groom accepted appraised goods of a mana, she must give goods worth 1¼ mana. If he accepted appraised goods worth 400 dinars, she must give goods worth 500, meaning there's a difference of about a fifth. The Gemara says by the promised dowry to a dead son-in-law, he can even refuse to give it if the second is objectively a far better son-in-law, like being a Torah scholar as opposed to the original who was an ignoramus. It also says that it teaches all the types of appraisals above, large, small, and by the husband and by the wife. New Mishnah. If the bride pledged to bring money as a dowry, it's increased by 50%. The groom accepts to pay 10 dinars for her cosmetics for every money she brings in. Rabban Shimon ben Gamliel says, simply everything is done just according to the local custom. Gemara further discusses these points and related incidents, which are discussed further. New Mishnah. The minimum for an unspecified dowry is 50 zuz. If they agree to not have a dowry, the husband shouldn't say he'll only start supporting the woman once she's in his house. If a charity is marrying off an orphan girl, the dowry minimum is 50 zuz, although if there's enough money, they should give as befits her honor. The Gemara gives the definition as to the zuz coin. There are related points brought on the importance of giving charity to orphans. It also describes how to give charity and more points on its importance. There's a story where the sage Mar Ukva would secretly give coins to one poor man from his town, so the poor man wanted to uncover who was giving him charity. So he went out to catch this person, who, as it turns out, was Mar Ukva and his wife. But before they were seen, they quickly ran away and jumped into a large oven. Mar Ukva's feet started to burn, but his wife didn't, and she said it was because she stayed at their house, so gave charity more often, and also that she gave prepared food, which benefits people immediately. It says they jumped into an oven, as it's better to jump into a fiery furnace than to embarrass another person. There are other points on the massive amounts of charity Mar Ukva gave, and that he gave half of all of his assets to charity before he passed away. Normally, you shouldn't give more than a fifth of your assets, but it's fine there as he was about to pass away. And there are further of such points, and they're discussed a bit further. New Mishnah. If an orphan was married off by her mother or brothers, and she consented to this marriage, the dowry is 150 zuz, and she can get her full inheritance when she becomes an adult, once the marriage actually fully goes through. Some say if the father married his first daughter and then died, the second daughter's dowry should be the same as the first. Others disagree, saying people's financial situation changes, so it goes according to the estate at the time. The Gemara says an opinion that to determine the dowry of an orphan, you look at the character of the father when he was alive, if you can. Otherwise, it's a tenth of his estate, and this is for the debated, and others support this. It's for the debated as to who we hold like, and there's additional particularities in these laws discussed. It's decided we collect such payments from real property, not movables, whether for sustenance or for a dowry. New Mishnah. If somebody deposits money with a trustee for his daughter, there's debate if the daughter can tell him to give it to her husband. This applies by an adult. The Gemara describes these cases, which are qualified further. And that's the end of chapter 6. Chapter 7 of Tractate Kesubos further discusses various laws of marriage and related concepts. The first Mishnah says, if a man takes a vow against his wife benefiting from him for up to 30 days, he must set up somebody to support her. If it was longer than this, they must divorce, and he pays the marriage contract. Some say that's by Yisrael. By a Kohen, it's a 2-month minimum. If a husband confirms activating a vow for his wife, such as that she won't eat a certain type of fruit, they must then divorce. Some say this is if the vow was for more than 1 day by a straw. By a Kohen, it should be 2 days. If somebody confirms and activates a vow for his wife that she won't wear a type of perfume, they must divorce. Others specify if it was a poor woman, they divorce if there's no specified limit, and if it's a wealthy woman, then it's a 30-day minimum. The Gemara further clarifies where the husband vows against supporting his wife. It's where he says she should take her earnings instead of his food provisions, and she needs support as her earnings aren't also enough to pay for her small items that she was accustomed to getting from her father's house. That's why there's a 30-day minimum, because that's when people will hear about this and embarrass her. There are other answers given. The way he can have somebody else support his wife without it being through him, as he vowed against this in this case, is he says if somebody does so, they're just not going to lose out. It further debates if this is considered to be legally his agent, and the remaining points are for the qualified and additionally discussed. New Mishnah, if somebody vows for his wife that she should not go to her father's house if they live in the same city, if it's for under a month, it's fine. If it's for more, they must divorce. If the father was in a different city, then it's fine if it's for just 1 holiday. Not so if it's for 3, where they must divorce. If somebody vows for his wife that she shouldn't go to a house of mourning or feasting, they must divorce, as he's locking her inside. There's an exception to this, which will be explained. If the husband says he'll annul a vow on condition that she tells him something that somebody else said, or that she tells somebody something, or to take care of the garbage, which will be defined, they must divorce. The Gemara discusses this and brings sources which show a daughter wants to visit her father, hence the above ruling. There's further discussion the exception to the husband being allowed to vow her away from mourning or feasting house is if there's an established factual concern of promiscuity. The things the husband can't force his wife to say are shameful things, and some say taking care of the garbage is a euphemism for preventing conception. Others say it means to dump pitchers of water in a garbage, which looks insane. There are further examples of impermissible vows. New Mishnah, the grounds for divorce without paying a Kesubos marriage contract are for violating Torah law, secretly feeding the husband untithed produce, cohabiting as a menstruating nida, not separating the chalatayv, or not fulfilling the accepted vows, and also for violating general Jewish practice like wearing her hair uncovered, spinning in the marketplace, speaking with many other men. Some say cursing his parents in his presence. Some say being noisy enough that her neighbors hear her. The Gemara further qualifies these points, and they're additionally discussed as to how these different acts are considered forms of promiscuity. New Mishnah, if a man betrothed the woman on condition that she's not taken any vows or that she's not blemished, and then discovers that she had vows or blemishes, this is not a valid betrothal. If this was not stipulated and they marry, and then he finds out that she had vows or blemishes, this is grounds for divorce without paying the marriage contract. All bodily defects that disqualify a Kohen from service in the temple are considered legally defects by marriage. The Gemara says this is all also cited in a later tractate, Tractate Kesubos, as it involves betrothal and also marriage contracts. The types of vows that invalidate such a marriage are vows against meat, wine, or colored clothes, and we bring sources which are further qualified. There's additional discussion on these points and further particularities in these details. It's said if a woman then annuls her vows, she's back to being betrothed. But if a woman goes to a doctor to remove her blemish, she's not back to being betrothed. This is because a vow is annulled retroactively, unlike a blemish. Others disagree with this principle. As for the discussion, it lists blemishes that qualify here as legally a blemish, which are discussed. New Mishnah, if a blemish was found on the woman after betrothal, but while she's still in her father's house, the father must prove the blemish appeared after betrothal so that it's the husband's loss. If the woman was in the husband's domain, it's the husband's responsibility to prove the blemishes were there prior. Some say this is only by concealed blemishes, and he can't make a claim by exposed ones as he would have just seen them. If there's a bathhouse, he can't even complain about concealed blemishes, as his female relatives in theory would have told him if there were blemishes. The Gemara further discusses these opinions, which are further qualified along with many additional points. New Mishnah, if a man develops physical defects after marriage, he's not forced to divorce his wife, although some say we do if they're major defects. The Gemara says some of this applies even if the defects were there prior to the marriage, and she could demand a divorce by a major defect, saying she thought she'd be fine with it, but as it turns out, she just couldn't deal with it. It defines major defects, blindness, a severed limb, and similar. It debates who we hold like as to if a woman is allowed to demand divorce after a major defect. New Mishnah, physical defects on a man that can force a divorce are things like boils, polypus, also somebody who works with excrement, a copper refiner, and a tanner can have a divorce demanded from them, and all these apply if these were the case before or after marriage, and the wife can say that she thought she could deal with it, but as it turns out, she couldn't. Others say she must still be with him, besides for by boils, as his flesh falls apart. And there was an incident where a woman was married to a tanner, her husband died, and she refused to marry his brother, who was also a tanner, saying she just couldn't tolerate him. The Gemara defines illnesses and forms of work. We also force a man to divorce if he refuses to feed or provide for his wife. Some say we only force a divorce if a man is married to a woman disqualified to him, and there are instances of this given. It further defines these diseases, along with several others, and medicinal cures for some of them. There's an instance where the sage Rabbi Yeshua ben Levi was about to pass away, and the angel of death was told to fulfill his request. So Rabbi Yeshua ben Levi asked to see his portion in the Garden of Eden, and also asked to hold on to the angel of death's blade. And when they got to the Garden of Eden, the sage jumped in with the blade and swore not to leave. It was a whole issue, and it was said that he didn't need to leave, as he'd never had an oath annulled during his entire life, but he did have to return the blade. Anyways, it describes the sage entering the Garden of Eden, and he was asked if there was ever a rainbow seen during his time, which is a negative sign, and he said yes, but that wasn't true, he was just being humble. Another sage, Reb Chanina bar Papa, also met the angel of death as he was about to pass, and he made the exact same requests to have some time to review his studies, and to see his portion in the Garden of Eden. And then he asked for the angel's blade, but the angel of death refused, saying he was not going to fall for that one again. It also says that when this sage passed, a column of fire appeared to separate him, which traditionally only happens for 1 or 2 people per generation. And there are a few other points on the mentioned diseases, and that's the end of chapter 7. Chapter 8 of Tractate Kesubos covers further additional laws of the marriage contract, the kesubah between husband and wife when they marry. The first Mishnah says if a woman inherited properties before the initial stage of marriage, she's then allowed to sell or give them away, and it's a valid transfer. If she inherited the property after the initial stage of marriage, Beis Shammai says she can sell them, Beis Hillel says she cannot. It's agreed that if she did, though, it's still a valid transfer. It's questioned why, and it's said that they really do not actually understand the logic of the established principle that after marriage the husband can undo a sale with his wife's inherited properties, so they're not about to institute this also with properties inherited prior to the completion of the marriage. Anyways, if she inherited the properties after the completed final stage of marriage, the husband has the right to take them away back from the buyers. If she inherited the properties before the final stage of marriage and became fully married then, some say this is a lasting transfer. The same logic as above applies. Some distinguish between types of property, saying property known to the husband the wife cannot sell, and it's a void transfer, and if they're not known to the husband, she can't sell them, but if she did, it's a valid sale. The Gemara says the difference between before and after betrothal is that the properties are under her jurisdiction prior. After the first stage of marriage, it could be under hers or under his, so she can't sell it, but if she did, it's a valid sale. There's further discussion on this. It speaks on some specific cases. Others say if the woman acquired properties before or after the first stage of marriage, if she then gets fully married, her husband can revoke any later sale of them. This is disagreed with by a few others. Everyone agrees if she inherited the properties after the final stage of marriage during her life, the husband can revoke their sale. The definition of known and unknown properties are known properties are land, unknown properties are movable. Others disagree, saying that both of those are known, and unknown property is property that the woman acquired that's currently overseas. We bring proofs for that definition. Once a woman didn't want her property to go to her husband, so she signed it all away to her daughter beforehand, and then later divorced her husband, but a sage invalidated this. It's debated if this was valid. There's a bit of an argument. It said the property is considered like unknown property to the husband in accordance with the opinion that says that such property is actually retained by the wife. New Mishnah, if a married woman inherits money or detached produce, it should be used to buy land and the husband can eat of its produce. If she inherited produce attached to the land, some say they calculate how much more the land is worth with the produce, and that amount is used to buy land which the husband can eat from. Others say that the attached produce belongs to the husband, while detached produce should be used to buy land. As a general principle, wherever the husband has the advantage by marriage, he has a disadvantage by divorce, and vice versa. For instance, when he marries, the husband gets attached produce, and if he divorces, she gets the attached produce. With detached produce, by marriage, she gets it, by divorce, he gets it. The Gemara says, in regards to land purchases, land is always purchased over a house. Houses are always purchased over date palms. Date palms are always purchased over other fruit trees, and fruit trees are purchased over grapevines. Regarding sorb trees or a fish pond, there's debate if those qualify as land or as principal. Generally, if a trunk regrows, it's considered to be produce, otherwise it's considered to be principal legally. There's further qualification on these points. New Mishnah, if a woman inherits old slaves or maidservants or old olive trees and grapevines, they should be sold and used to buy land which the husband can use. Others say they're not sold, as they represent the prestige of her father's house. The Gemara says the dispute on the use of trees is only if she didn't also inherit the field. If she did, it's agreed that she does not need to sell them. New Mishnah. If somebody spent money on his wife's property and then divorces her, no matter what he spent, he can't demand compensation from his wife unless he only spent and didn't consume, in which case he swears what he spent and can take compensation. The Gemara says it said he can't demand compensation if he consumed even a little bit of the produce. Some say this is even a single dried fig, assuming he didn't eat it quickly. Others say it's even if it's as small as a case of pressed dates, and it's unresolved if he benefited from a cake of squeezed out dates. If he ate the produce quickly, it's debated as to how much he needed to eat. There are a few other particular incidents mentioned of such cases, and for the discussion, which all goes further. New Mishnah. If somebody pending Yibum inherited property, it's agreed that she can sell them or give them away, and it's a valid transfer. If she died while pending Yibum, Beis Shammai says her marriage contract and properties are divided between her husband's heirs and her father's heirs. Beis Hillel says that everything stays with whoever has it, so the marriage contract would be with her husband's heirs, and her property would stay with her father's heirs. If the dead husband left money or detached produce, it should be used to buy land that his brother can eat from. If he left attached produce, some say an appraisal is made, and the extra money the land is worth from the produce is used to buy land. Others say attached produce goes to the brothers, and detached produce goes to whoever acquired it first, and if it went to the wife, it should be used to buy land. If they marry, they are considered husband and wife in all respects, besides that his marriage contract obligation is on the estate of the first husband. The husband can't designate part of his brother's property as the marriage contract to be able to access the rest of the property. Actually, all of the first husband's property is pledged as her marriage contract. This also applies by a typical marriage. If the Yibum couple divorce, she gets her original actual marriage contract. If they remarry, she's like a typical remarried divorcee and is entitled only to the original marriage contract. The Gemara says, if a woman pending Yibum dies, it's debated who has to bury her. It said it's the Yibum brother's responsibility. We bring sources, although it's debated based on the logic of some related cases. Therefore, there are particular cases discussed, and it goes further through what rights exactly the brother that's doing Yibum has to the original husband's estate. There are further points. It says by the Yibum marriage, the marriage contract goes to the estate of the first husband, as the new husband isn't really fully choosing this marriage. If there is not a marriage contract from the first marriage, they have to make a new one to decrease the possibility of divorce. The remaining points are also discussed, and that's the end of chapter 8. Chapter 9 of Tractate Kesubos continues on the laws of the marriage contract. The first Mishnah says, if somebody writes to his wife that he's relinquishing all of his rights to her property, he's still allowed to consume her produce and he still inherits from her if she dies first. However, if she decides to sell her property, it's a valid transaction. If he relinquished all of his rights to her produce, he can't eat her produce, but he still inherits from her. Some say he always can eat some of her produce unless he specifies he's relinquishing his rights to the produce of her produce infinitely. If he relinquished the rights to her property and produce, or produce of her produce, during her life and after, he can't eat of her produce or inherit from her. Others say he does still inherit, as such a stipulation goes against the Torah, which makes it void. The Gemara says such a relinquishment can also be done orally. It brings proofs that a husband actually does have the ability to waive his rights to his wife's property or produce like this. Some say this is only effective during the initial stage of marriage, as during the later actual final completed stage of marriage, they actually equally share the property. Some hold that he actually has a greater share of the property, so there'd be a practical difference by a woman who's pending Yibum. There are related points discussed by property ownership. There's more on this. It asks why he needs to say the produce from the produce until infinity to give up his wife's produce, and it's unresolved as to why you need each part of that phrase. There's further discussion, and it's ruled like the opinion that a husband can't relinquish his inheritance from his wife, but due to a different reason. And it's debated as to what exactly this reason is. Then, according to this opinion, a husband inheriting from his wife is actually rabbinic. It's just that he says rabbinic laws are very strict, so they still can't be violated. And this is further discussed. New Mishnah, if somebody dies leaving a wife, creditor, and heir, and he had a deposit or loan with others, some say it's given to the weakest of them, others say it's given to the heirs, as those don't require an oath to collect. If the dead man left detached produce, whoever gets it first gets it. If the wife or creditor took excess, more than what they're owed, some say it should be given to the weakest, others say to the heirs, as they don't require an oath to collect. The Gemara says the case has him leaving a loan and a deposit, as we need both. A loan is given to be spent, while a deposit is given to be held. This would create variation between the opinions if both weren't mentioned. The weakest of them, some say this means this would be the one with the weakest proof. Some say it means to give it to the woman for her marriage contract, so that way it'll function easier and women will marry more. There are similar points regarding the excess detached produce. The second opinion that says it goes to the heirs would say actually all the produce does. He just mentioned excess here, as the first opinion did that also. It's debated where the produce goes if it's kept in a recessed area near a public road. There are related points discussed and a few particular incidents regarding creditors of a deceased individual. These cases are discussed further, and there are further particular relevant incidents listed. Another point, if a man owes money to a creditor and for his wife's marriage contract, and he has land and money, the creditor gets the money and his wife gets land. If he only has land to give one, it's given to the creditor, as we're not concerned about women just not marrying anymore because of this one particular situation. There was a case where a man didn't have money to pay a creditor, but he did have land, and he was told to sell his land to pay the creditor, but that was only because he had lied and said he had no money, so the court decided to act stricter with him. According to the opinion that says repaying a creditor is the fulfillment of a mitzvah, it would be a positive commandment, which you're allowed to force somebody to do. There are further particularities by cases of a divorce document. New Mishnah, if one has his wife as a storekeeper or his business administrator, he can make her take an oath that she was honest with the business dealings if he wants. Some say he can even make her swear he didn't take his stuff outside of work. The Gemara says, according to this latter opinion, it's debated based on if the husband can be so imposing. Even if she's also sworn by the business, according to this opinion, the oath outside of business can be made even before the oath within business. New Mishnah, if a husband writes to his wife that he won't make her vow or oaths, he can't do that with his wife, but he can with her heirs and successors. If he wrote that he won't vow or oath with her or her heirs and successors, he can't impose an oath on any of them, although his heirs can. If he wrote such an oath, and also specified that his heirs can't impose such an oath, he and his heirs can't impose oaths on her or her heirs or successors. However, if the husband died and the wife went back to being the administrator of her husband's business, his heirs can make her take an oath about future events, but not about past ones. There's debate about what type of oath is exactly being referred to. Some say it's over the administrative position, others say it's over her trying to impair her marriage contract. This is further discussed. It goes through various different phraseology of the husband to free his wife from oaths, as to which are considered to be legally effective and which are not, and for what. It said we hold out the opinion that he and his heirs cannot impose oaths, whether he wrote without oath, clean of oath, without vow, clean of vow, or my possessions, or these possessions. New Mishnah, if a woman impairs her Kesubos marriage contract, admitting it was partially paid, or there's one witness that her marriage contract was paid, she must take an oath to collect the remainder. She'd also need an oath to collect her marriage contract from the property of orphans, from encumbered property, or if she's doing this not in her husband's presence. A woman impairing her marriage contract, for instance, it was for 1,000 zuz, and the husband said, I already paid it, and she says, no, you only paid 100 zuz. She collects the remainder with an oath. The case of a single witness is if the marriage contract was for 1,000 zuz, her husband says he paid it, she says, no, you didn't, and a single witness says, yes, he did. She'd need an oath to collect the payment. Collecting her money from encumbered property is where the husband sold his property and she's collecting her contract from the purchasers. It must be done with an oath. Collecting from orphans' property is where the husband died and left his property to orphans. She's collecting from them with an oath. Him not being in her presence is where he's overseas, so she, again, must collect with an oath. Others say, whenever she claims her Kesubos contract, the heirs can impose an oath on her, and if she doesn't, they cannot, and this will be explained. The Gemara suggests that by the impaired contract, it's a biblical oath, as she's admitted to part of the claim. This is rejected, as it's only biblical if she's not paying, and here she's taking payment, and also it's not biblical to swear on the denial of land lien. Rather, it's said that this is a rabbinic oath to make her pay attention when she's paid. It's unresolved if we assume it's true if the woman impaired her contract while there were witnesses there. It's also unresolved what if the impaired amounts are in very small numbers, such as under a peruta currency. There's no oath imposed on a woman who devalues her currency, and there's a presumption of trust between the husband and wife, as the original contract is now admitted to be void. There's the same debate if the oath by a single witness is biblical or rabbinic. It's said to be rabbinic, and it's done to put the husband's mind at ease. If the husband wants, he can make the woman take a biblical oath by re-giving the woman the contract payment before the first witness and the second one, and then establish the original payment as a loan, thereby forcing her to now take a biblical oath. This only works if he tells the witness what's going on beforehand, so she can't claim there were just two marriage contracts. There are related cases discussed. It also debates exactly which cases the last opinion was referring to, which was on the earlier Mishnah back on 86b and others. New Mishnah, if a woman brought out a divorce document but no Kesuba marriage contract, she can still collect her Kesuba. If she had just the Kesuba but no divorce document, meaning she says she lost the divorce document and the husband says that he had paid it and lost his receipt, or similarly if a creditor brings a loan document but no document authorizing the court to collect his debts, neither the woman nor this creditor can collect their payments. If it's a dangerous time, it's so that they can collect such payments without those other typically necessary documents. The Gemara further discusses these points, which are qualified further at length. New Mishnah, if a woman produces 2 divorce documents and 2 Kesubos marriage contracts, or 2 Kesubos and 1 divorce document, or 2 divorce documents and 1 Kesuba, or a Kesuba, a divorce document, and proof of her husband's death, she gets 1 Kesuba payment, as if somebody divorces and remarries his wife, he does so based on the first Kesuba without rewriting one. The Gemara discusses this further. New Mishnah, if a minor was married off by his father, which is not legally allowed, however the marriage does go into effect when this person becomes of age, the Kesuba that was written while he was a minor stays in effect. This also applies by a convert who converted with his wife. Their marriage contract stays in place from before the conversion. The Gemara debates if this contract is just the base minimum of 200 zuz, or if it also includes any extra sums added. It said no, it only refers to the principal minimum of the Kesuba. And that's the end of chapter 9. Chapter 10 of Tractate Kesubos covers additional laws of the marriage contract. The Mishnah says if somebody was married to 2 wives and he died, and there's not enough money to pay for both Kesubos, the marriage contracts, the first wife has priority for payment, and the heirs of the first wife have priority over the heirs of the second wife. If he married the first wife, she died, he remarried, and then he died, the second wife and her heirs have priority over the heirs of the first wife. The Gemara suggests, based on the wording, that if the second wife takes her contract first, she would be allowed to keep it, which would mean that if a person had 2 creditors he owed money to, and the second creditor comes first, he can collect his money, seemingly. This is rejected based on similar uses of this wording. Some say the entire argument happened in the inverse, actually. Further, from the Mishnah, it can be learned that if a man's 2 wives die, one during his life and one after, the heirs of the first wife have priority to the marriage contract for the male children, and there's no concern of this causing argument. Also, we can learn that a Kesuba can become surplus to another Kesuba. We can also learn that the Kesuba towards sons cannot be collected from encumbered property. The logic of these conclusions is described, and the validity of these statements are debated from several sources. It's further debated and ruled that if a man's 2 wives die, one before his death and one after, the heirs of the first wife have rights to the Kesuba for sons. Also, it's ruled that a Kesuba can become surplus for a counterpart Kesuba. It explains the necessity for both of these statements according to various opinions. New Mishnah, if somebody married 2 wives and both of them died, and then he died and there's only enough money to pay for the Kesubos, the money is split equally between them, and if there's any surplus money, the Kesubos are paid as written and the surplus is split between them. The property is appraised by a court, so no party can inflate the value. If there are prospective assets in the estate, they are not treated as owned. Some say even movable property is not counted. The excess money split only occurs if there's enough actual property to pay the Kesubos in full and a dinner more. The Gemara discusses these points. There are a number of relevant cases cited and discussed in regards to property collection and similar, which are further discussed. There are a few additional rulings mentioned, such as if a person sold a field to another with a guarantee and the creditor comes to collect money from the first person, so he goes to the field he sold to the second man. The first man can argue on behalf of the second person to not take the field, as he is going to have that amount of money taken away from him by the second guy. Some say this applies even if there's no guarantee, as the first person is considered to be a concerned party, as he doesn't want the second man to get upset at him. Additionally, some rule that if one man sold a second man a field without a guarantee, and then protesters claimed it was never the first guy's field to sell, so long as the second guy hasn't made a proprietary act to claim the field, he can retract from it without paying. A proprietary act is like walking along the border of the field. Some say this applies even if a guarantee was made. New Mishnah, if somebody marries 3 wives and then died, and the Kesubos were 100, 200, and 300 zuz respectively, and he only has 100 zuz, it's divided equally. If he has 200 zuz, the first one takes 50, and the second and third take 75 each. If there were 300 zuz, the first takes 50, the second takes 100, and the third takes 150. The system also applies if people deposited money in a fund, and they had a loss or a profit, it's divided like above. The Gemara explains by the middle case, the first woman got 50 zuz, as the second woman removed herself from the claim to the first 100 zuz, so it's being split between the first and third woman. However, the second woman still gets her amount because she didn't totally remove herself from her necessary payment. Similarly, by the third case, the third third wife removed herself from the claim to the first 100 zuz. Others suggest these cases deal with 2 different seizures of property by the wives, which is described. This is further discussed. New Mishnah: if somebody married 4 wives and died, the priority goes in order of marriage, and each must swear to the next that they haven't yet been paid, although the 4th does not need to do this. Others say the 4th actually must collect with an oath. If the Kesubos were all written on the same day, it goes by order still of who was written first, by the hour, which was recorded on these documents in Jerusalem. If they were all written within the same hour, and there's under 100 zuz in the estate, it's divided equally. The logic of the dispute is debated along with related points. These are further discussed along with further cases of conflicting deeds which have the same date. New Mishnah: if somebody married 2 wives, sold his field, and the first wife wrote to the field buyer that she has no claim over this field. When the husband dies, the second wife can collect the field from the buyer, and the first wife can take it from the second, and the buyer can take it from the first, and they can just keep on going around in circles until they reach a compromise. This also applies by a creditor and a wife who is her husband's creditor. The Gemara says the case is where the buyer did an act of acquisition with the field with the wife, so when the woman rejected the field, that has legal validity. Others disagree, and some suggest this is dealing with a divorced woman to make the case work like everybody. There's further debate on this. It's discussed, and it's ruled that if free property becomes ruined, a creditor can collect from encumbered property, and there's further discussion on these points. And that's the end of chapter 10. Chapter 11 of Tractate Kesubos continues discussing the laws of a marriage contract. The first Mishnah says, a widow is supported from the property of the orphans. Her earnings belong to them, and if she dies, they are not obligated to finance her burial. That's her heirs, those who inherit her marriage contract's responsibility. The Gemara debates based on the practice of regions. If a widow is actually supported from the orphans, further, it's said that all of the things a woman is obligated to do for her husband, a widow must do for her heirs, besides for mixing his wine, making his bed, and washing him. Similarly, all tasks that a slave does for his master, a student does for his teacher, besides for untying his sandals, if he won't be recognized as a student. If he's wearing tefillin, he's always allowed to, as he won't be mistaken as a servant. It speaks on the importance of a student serving his teacher. If a widow took movable property as payment for her support, that's allowed, and we bring sources. This isn't allowed if it's taken for her marriage contract payment. It's also said regarding retroactive sustenance, if a woman waits 2 or 3 years without claiming support, she has forfeited her rights to it. If the orphans claim they gave support and she denies it, it argues who has the responsibility to bring proof. It's debated from a number of sources. In regards to a widow selling their husband's property to get support, some say she sells property every 12 months, and she's provided for every 30 days. Others say she sells every 6 months and is provided every 30 days. And we bring sources which are debated. This was a discussion, and it says it's only from leftover lands that a woman can use to collect of her marriage contract. There are related points by general laws of sales, such as debate if a person sold land because he needed money and then found out he didn't need money, as to whether or not the land sale is now considered void. It's argued from a number of sources, and it's ruled that yes, the sale is now revoked. New Mishnah: a widow from either the first or final stages of marriage can sell her husband's property without consulting a court. Others disagree, saying if she was widowed from the first stage of marriage, she must consult a court, as such a woman has no legal right to sustenance, so therefore requires the court's approval. These points are debated on. New Mishnah: if a widow sold all or part of her kesubah, or pledged it as security for a loan, or gave it as a gift, the remainder can only be sold with the court's approval. Others say she can sell her kesubah in portions if she wants, and sell the entire estate for her support without the court's approval. When she sells property for sustenance, she should specify so on the sale document. A divorcee cannot sell her dead husband's property without the court's approval. The Gemara debates the author of this Mishnah based on the logic of different opinions. It debates a seeming contradicting alternative source, but it's based on the interpretation of the definition of a few words in regards to these laws. Based on a case, it seems to be held that if a woman gets part of her kesubah, she still retains the right to her sustenance. If a widow sells her dead husband's estate without asking the court, it's debated if she also needs to do this with an oath. They would hold that there isn't a public announcement required, which is debated, but we do hold that, and she does require an oath. New Mishnah: if a woman's kesubah was for 200 zuz, and she sold property worth 100 zuz for 200 zuz, or property worth 200 zuz for 100, it's ruled that she's relieved of her kesubah. If the kesubah was worth 100 zuz, and she sold property worth 100 100 zuz and a dinar, meaning more than what she's owed, for 100 zuz, it's void, even if she tries to return the extra dinar. Others say the sales always stand unless there's enough to leave over a 9 kav area in a field, or a half kav area in a vegetable garden, although some say even a quarter of a kav. If her kasuba was worth 400 zuz and the woman sold 3 pieces of property to 3 people worth 100 zuz each, and then to a last person she sold property worth 100 zuz and a dinar, the last sale is void and the first 3 are still valid. The Gemara says the issue in the first case, where she overcharged, is where the widow sold land which doesn't have a fixed price at double its worth. So according to this opinion, they would hold that all of the excess goes to the heirs. It's ruled that if an item has a fixed price, the excess is split between the principal and the agent. If there's no set price, the excess goes to the owner of the purchase money. There are related cases discussed. The validity of these points are further debated, citing a few other relevant discussions. It further discusses related laws of an agent by sale and whether such an individual maintains his status even if he does something that was not requested. Some say that a sale is valid if the error was made by the principal seller, but if the agent made a mistake and was overcharged, the sender of the agent can say, "You did not have my consent to do that," making the sale therefore invalid. It brings sources for this point, and there's further discussion on this. New Mishnah: if a property was sold after being appraised by judges, but they undervalued or overvalued it by a sixth, the sale is then void. Others say the sale does stand due to the authority of the court. If there's a letter of inspection written, even if they were way off, the sale still stands. The Gemara debates based on this if an agent is like a widow's sale, whose sale is invalidated if it's off by any amount, or like a court sale, whose sale is invalidated if it's off by a sixth. It's debated and said to be like the sale of a widow, meaning if it's even a bit off, it's invalidated. There can be variation by an agent buying teruma, as people can separate it in different amounts. It's ruled that a court sale of being off by a sixth is invalid by such a case. This is discussed with variation by particular cases. It's further ruled that if a widow sells her dead husband's estate, the sale's guarantee falls on the orphans as it would if it was sold by the court. This is stated to show that property purchased from the court will be guaranteed. According to the opinion that we don't invalidate a court sale, even if they're off by a sixth due to the authority of the court, the sale would still be revoked if it was off by half the property's value. This for the discussion on these points and a few related incidents. New Mishnah: a minor girl who refused to marry a husband, a secondary rabbinically forbidden relative, and an Ilonis, an underdeveloped woman, sometimes defined as someone with Turner syndrome, do not receive a kasuba payment, and they do not get the benefit from each other's property, nor do they receive support or old clothes. Regarding the Ilonis, if the husband married her knowing she was an Ilonis, she does receive a marriage contract. If there's another forbidden marriage, a widow marrying a Kohen Gadol, a divorcee marrying a Kohen, a mamzer, an illegitimate person marrying a regular Jew, they all still receive a kasuba payment. The Gemara debates if a minor who was preemptively divorced, if she still receives a kasuba payment or not. Further, some say an individual must wait at least 3 months before remarrying. It's discussed as to if there's any notion of validity to the marriage of a minor girl whatsoever. Rabbi Eliezer says there is none at all, it's completely forbidden and not legally binding, meaning there would be no kasuba. Others disagree, but it's explained that the logic is that they too hold it's not a legal marriage and forbidden. However, there was a specific case in those times by an orphan girl where there was a significant concern that people would take advantage of her if she wasn't protected, as here she has no father, so she can be legally temporarily put in the care of an individual, with the caveat that she'll be properly married to him once she becomes an adult, although this is a marriage that she could refuse if she wants, all done just to protect her from any exploitation by others. So according to this latter opinion that says she can be given by her family to another person, this is only done as long as she consents to this, and there wouldn't either be a marriage contract written. This for the discussion on the property entitlements of the different marriages from the Mishnah. There's more on the case of the marriage to the Ilonis, where the husband is aware of this prior, and it's compared to the case of a widow marrying a Kohen Gadol, where she does receive a kasuba, and it's explained that's only if the Kohen Gadol was aware of her widow status prior to the marriage, and if he wasn't aware of this, there would be no kasuba. And that's the end of chapter 11. Chapter 12 of Tractate Kesubos discusses some additional laws on the marriage contract and the obligations between a husband and wife. The first Mishnah says if somebody marries a woman and they agree that the husband will feed her daughter from her last marriage for 5 years, he must do so. If they divorce and she marries somebody else and they remake the same deal, the first husband must still feed the daughter for 5 years and must bring it to her. The two husbands also can't split the cost of the food, each must fully supply the food in full. If the girl eventually marries, the husband provides her with food, and each of the stepfathers must also continue giving her food. If they die, their daughters are fed from unencumbered property, while this stepdaughter is fed from encumbered property, as she's legally considered to be similar to a creditor. It was advised that when originally making such a deal to agree to feed the daughter, so long as they're still married, to prevent some situations like this. The Gemara discusses a related case. If somebody tells another that he owes him money, there's debate if he must pay. If he did this through an unsigned note, as it's debated if such a note is sufficient to create indebtedness. It tries to prove from our Mishnah that such a person would be liable, as the case would be with a similarly unsigned document, but we say no, our case is with documents of allotment, which are legally valid, so can't be used as a proof. It further debates the argument from other sources, and the remaining points are further discussed. It also cites some relevant cases. New Mishnah: if a widow said to her husband's heirs that she couldn't bear to leave her husband's house, they can't tell her to leave, and that they'll support her. They must support her there and give lodging in accordance with her status. If the woman said she couldn't bear to leave her father's house, the heirs can say she'll be supported only if she lives with them. If she argues that it's inappropriate for her to stay with them, as she's a young woman and they're young men, they must support her where she is, even if it's her father's house. The Gemara further qualifies these points and discusses other things on the passing of the sage Rebbe, that he requested not to be eulogized in the towns, and many other points which are related. There's further discussion on a number of other sages. There are additional points on the passing of the sage Rebbe. He was extremely ill, but the sages kept praying for him so he wouldn't pass, and his maidservant, feeling bad for him, threw a vessel off the roof, causing the praying sages to stop for a moment and allowing Rebbe to pass on. There's further discussion on this. New Mishnah: if the widow is staying at her father's house, she collects her kesubah whenever she wants. If she's at her husband's house, she can only collect it until 25 years, during which she'll have done many favors to the heirs, thereby repaying her kesubah. Others say it's the inverse. She can collect her kesubah whenever she wants from her husband's house and within 25 years from her father's house. If she dies, her heirs must bring up her kesubah within 25 years, otherwise they forfeit their rights to it. The Gemara says that the 25 years are adjusted depending on the wealth of the widow. Further, the debt is considered legally forgiven right at sunset on the 25th, which is how many of such concepts work. It's also said the woman can collect her kesubah whenever she wants, if she has the actual document, but others disagree, keeping the 25-year limit anyways. It's debated. This is further discussed along with some related incidents, and that's the end of chapter 12. Chapter 13, the final chapter of Tractate Kesubos, covers some final additional laws of the marriage contract. The first Mishnah says there were two judges of decrees in Jerusalem. The first made two rulings which were contested, the first of which were that if somebody went overseas and his wife demands support, she needs to swear to claim her marriage contract, but not to claim this support. Others disagreed, saying she needs to swear by both, but it's debated between sages. The Gemara defines who these judges were, and what their jobs were, and how they were paid. It also speaks on how wrong it is to accept bribes and related verses. These points are discussed. It says a judge who borrows things without having anything to lend cannot be a judge. It said a judge shouldn't judge a person he likes or dislikes, and there are related points. It says you shouldn't even accept a bribe of words, which is somebody speaking politely to you or doing a small favor for you, and there are instances of sages who are judges having small favors done for them and then choosing to not judge those people out of concern of being biased, and examples of them not accepting gifts from individuals for the same reason. There's further discussion on this topic. It also discusses uses of the excess temple funds, different opinions as to where the different funds were spent, which was more lengthily discussed in Tractate Shkolim. There's further points on the above discussion. The original topic is debated, and it's ruled that we do give support to the wife of an absent husband. It's also ruled that a woman is legally allowed to refuse to work and still be supported by her husband. It also rules that by purging earthenware vessels to make them kosher, it can be done by black and white earthenware vessels, but not by green ones, which have absorbing qualities due to their high alum content, and if the vessels have cracks, they're all forbidden. New Mishnah, the second of the contested ruling from the first judge, was that if somebody went overseas and somebody else supported his wife, the second man is not reimbursed. Others disagree and say he swears how much he spent, and he collects it back. It's debated between sages. The Gemara further debates this point. New Mishnah, the other judge made 7 contested rulings. The first was if somebody dies leaving behind sons and daughters, if he has lots of property, his sons and daughters are supported. If he doesn't, then he supports only his daughters. Others disagreed. The Gemara says they argue, saying if men inherit when there's lots of property, why should they not when there's less? New Mishnah, the second contested ruling, if somebody claims jugs of oil from somebody, and the man said he owed empty jugs, as he admitted he owed something, he must swear this. Others disagree, saying the partial admission is not considered to be a full claim. The Gemara explains the debate is based off the wording, if he's including the actual jugs along with the oil, which is qualified. New Mishnah, the third contested ruling, if somebody promised his son-in-law money in his dowry and then refuses, the bride can tell the groom to either marry her or not, and to not make her wait based on her father. The Gemara explains this case and says, by these 2 contested rulings of the first judge, we hold like him, and by the first 3 contested rulings of the second judge, that's what we hold like, and not by the last 4 rulings. New Mishnah. The 4th contested ruling, if somebody challenges the ownership of a field but is signed as a witness on the deed that records the sale, he can still argue that he only signed the sale as a witness between those 2. However, he actually owned the property, and he did the sale because the first man who owned it was tough, and it would be difficult to get his land back from him, so he had it sold to somebody else so that way he could now get it from this guy. Others say he's lost it now that he's signed its sale as a witness. Also, if he used this field as a boundary mark in the sale of a neighboring field, he's lost his rights to the field. The Gemara further discusses the point and qualifies it. New Mishnah. The 5th contested ruling, if somebody returns from overseas and he finds the path to his field is lost, he can take the shortest path. Others say he should either buy a path at whatever its cost, or he should just fly across to his field or something. The Gemara further explains the logic of these cases and some related ones. New Mishnah. The 6th contested ruling, if somebody brings out a note of indebtedness against somebody and the other man brings out a deed of sale of a field and can claim, if I was in your debt, you should have taken it out of this field sale. Others disagree, saying maybe he sold him the field so he could collect it from the loan. The Gemara explains that the argument is where they write the deed first and then give the money in that location. So the first opinion says if the field was sold as security, he should have said so before. The others would disagree, as they say the purchaser would have eventually found out about it from other people anyways. We mentioned the last of the 7 contested rulings. If 2 people produce notes of indebtedness against each other, the second could say, how am I in your debt if you borrowed from me? Others say that they must collect the debt from each other. The Gemara says if you do this, they can just keep the money as they have it, if it'll fill out each other's debts. If it's a seizure of land property, if they own average and inferior land, it's debated if they swap the land, as they judge the land in relation to what they have, so they'll end up collecting different land. While others say they collect in relation to what the world considers to be good land, so they'll just end up swapping the same land, so they just keep what they have. Those are the discussion on these points. New Mishnah. In regards to marriage, there are 3 regions: Judea, Transjordan, and Galilee. You can't require your wife to move with you to a town or city in between regions, but you can if it's within a region. You can't have her move from a town to a city or a city to a town. You can have her move from a bad dwelling to a good one, but not vice versa. Others say you can't even make her move to the good dwelling, as it could be bad for her health. The Gemara says the issue with moving from city to town is as towns have less commodities, and the issue with moving to a city is based on a verse. It discusses the illness from moving to a good dwelling. Some say it's from a change of routine. It's discussed. New Mishnah. A person can require his household to move to Israel, but he can't make them leave. He can force them to move to Jerusalem, but he can't make them leave. This applies by men and women. If somebody marries and divorces a woman in Israel, he pays the Kesubos in coins of Israel. If he married her in Israel and divorced her in Cappadocia, he pays her in coins of Israel. If he married her in Cappadocia and divorced her in Israel, some say you pay with Israel coins, some say with Cappadocia coins. If you marry and divorce in Cappadocia, you pay with Cappadocia coins. The Gemara says even servants can be made to move to Israel. Others say you can even move there from a good dwelling to a bad one. Those points are further discussed along with similarly related topics. It debates based on verses if we're allowed to immigrate from Babylonia back to Israel. There are related points on this, and it talks about how great the men of Israel are and how great the land is in regards to a number of topics, like in regards to the resurrection of the dead, and it says that those in Israel will rise and everybody else will have to roll there through tunnels before being resurrected in Israel, which is why Yaakov, the forefather, wanted to be buried specifically in Israel. And further discusses many of the great miracles of Mashiach's coming, on the great produce of the land then, which is described in related points. It further brings points on the great fruitfulness of the land of Israel, which are discussed. It also speaks on the love of the sages towards Israel, more on the great blessings of Mashiach's coming, and it ends by saying that in the generation that Mashiach will arrive, there will be great vilification and criticism of Torah scholars, and there will be harsh decrees against the Jewish people, which will increase. It ends by citing a verse which teaches that all the barren trees of Israel will one day bear fruit. And that's the end of chapter 13 and the entire Tractate Kesubos. Alright, that was a lot of information, so here's a rough summary of a lot of the practical takeaways from this tractate. When a husband and wife marry, they sign a marriage contract called a kesubah. This contract outlines the sum given to the wife upon the termination of the marriage, a dowry, the delineation of finances and property between the two of them, and the marital obligations and responsibilities between the husband and wife. There are severe penalties and fines for the violation or premarital seduction of a woman. These include a minimum set fine in addition to a variable fine for humiliation, deprecation, pain, and others. In the case of a violator, he can be forced to legally marry the woman, essentially to make him financially responsible to take care of her for the rest of his life. And that's about everything. Thank you so much for watching.